You are welcome once again. Bright English is my name. This is the Legal Forum always, and today the topic documentary evidence. When we talk about documentary evidence, everybody can get to understand what is a document, and maybe many people think that a document is just a written thing that is presented for the inspection of court when the time of giving evidence in court. Now, but here, the Evidence Act, Cap 8 of Uganda defines documentary evidence as all documents produced for the inspection in court. So here, you have to understand that a document is when you find at any time when in court evidence is given in different ways. But anyway, where you find evidence is compiled or written, that written document of evidence or any form that has come for the inspection of court. Now, that's what we call understand or what we can call the documentary evidence. Because it is a document brought in court. Then the court will inspect a document where all evidence are arranged. Then it will be used at the time of court proceeding. So a document means more than what people think, because it is beyond the ordinary meaning. But here, a document means anything that's brought in court and for the court inspection. It is not only written submissions, but also can be the tape, videos, or any other documentation, the documentary where evidence can be good. Because when you see, we have the tape, all these things that contain video, audio type of thing, plus the document, the written submission itself. So, in Salahuddin versus R, the issue was whether the tape recording produced as evidence, and court admitted it. Yes, in Salahuddin versus R, the court allowed uh, tape recordings as evidence, because this is the case where we saw someone was somewhere being someone who was giving confession somewhere, and it was recorded. So in such recordings, it was once brought in court for the inspection. Being that it was a tape recording, then court came out and said that it can be taken as evidence. But without wasting time, let's go deeper and understand this document. And the document is classified in two ways: attested and unattested. So, attested means that the court will first attest or witness the document before it is allowed to be used. An example, the will is a good example. When the will is brought in court, it has to be attested or witnessed by some of you may call them um, the one who were present at the time of the will was made, or if there is nobody who can come to testify, they can rely on the handwriting and see whether the handwriting was for the deceased or not. So that is attested document. This needs to be uh, witnessed. These were all provided under Section 67 of Evidence Act, which provides that if a document is required by law to be attested, it shall not be used as evidence until that document is attested first. Now let's see an attested document. These are not required by law to be witnessed. That is Section 71 of Evidence Act, which provides for the proof of documents not required by the law to be attested. So the difference here between is the proof of the document, where the document will not be need to be witnessed or testified, as simple as that. Now let's look at what we call public document and private document. What is public document? Public document, these are documents which are available for everybody to access. How do you understand that? Now, I'll give you the example of statutes like penal code. It is a public that at any time you want it, you'll access it. Because at the time when the law is the act of parliament, when the parliament passes the law, they put in gazette for every person to know about it. Which means actually there are some instances where you find that at any time when you want to receive some information, you are allowed to go and ask and see the information. Then which means those documents are called public documents. Then private documents, these private documents, these are documents which may cause them personal. An example is a will. It is for, it is not, it is an opposite of public, or it is an opposite of, yes, an opposite of public. Private, as is a private document, and these are proven by original. But public documents are proved by certified copies or certified copy. I will give you an example that when you want to know that the law is repealed, or you want to know that this document, you want to know the originality of the document, then you have to require for the its originality. You commonly see some books you will find the reference, the time of publication, let's say the author's name with time. So when you Google that or when you put that into system, it will show the originality. Basically, it will show the originality of the document. So that brings us to the two aspects, the primary and secondary. Basically from section 61, 62, and 63. So when you look at primary documents, these are documents in their original form. The will is in its original form. Then secondary, these are the copies of primary documents. Now, Section 61 of Evidence Act provides that primary evidence of document means the document itself produced for the inspection in court. The original version way of a document is primary document. The photocopy of a primary document is a secondary document. Hope we are at par. Secondary documents, they include the certified copies. Copies made from the original. This means that at any time, uh, as we have said, you have the laws of the acts, like the penal code. I may show you this. This is the law, the act. Now, so when you go deep in this act, as you have seen, this is a photocopy. But if you want to know the source of this document or its original form, then there is what we call a certified copy or its original form, because they sat down and made one copy which was original. Then they made a lot of copies from one copy, and those many copies are called secondary documents. These are secondary documents. Now let's go to the proof of documents. So now before the document is admitted in evidence, it must be proved to be genuine or to be real, to be in its original version way. So before you are saying you are using this act as the evidence, then it must be genuine. The genuineness must be proven. And how can we prove the genuineness? Here we have the general rule. According to section 63, it shows that primary proof of document by primary. So we prove the document here, which is secondary, by primary. This is secondary document. It is a photocopy of the original. So if you want to prove the genuineness, the originality, the original version way, we have to see or to look for that. We have to look for what? For the original or the primary document. I think we are moving at fast. Now we have to look at the proof of primary or the proof of public document. They say that a certified copy of a document is required until proven. Yes, that is a public document. What is a public document? I've said this is both a primary, a secondary, and a public document, which means everybody can access the information here. So in proving even a public document, then a certified copy of the document is required. What is a certified copy? If it is prove the certificate of education that I got, its certified copy is the original that is in the institution. So they have to come to the institution where I studied, they get that original version, the original document of it, and then they prove money to be used. That's why in certain companies or anywhere, when they want to prove that you really studied A level or level, you firstly will first conducted through the system and get to know this original. Have you ever get to know uh, why they just want to know that you have the original copy? Because for you will present, but they will put in the system to track the system, to track the original in your name and understand. Sure, is this the original or it is the copy presents the original? And once they track the original, that means they have seen the primary and the general root is proved by primary, which means there is no now need to there is no need to to worry. So they just take it to be it what they need. So when you look at section 43 of Evidence Act, um, it shows how it shows that such can be done by expert and non-experts. What can be done in expert and non-expert? The handwriting proven. Now, if this goes back to where you find like a will, uh, there is no one to prove or to testify or to witness, then they will see the writing. That writing will basically be done by experts. They will bring the expert on an expert as him is ready. This handwriting is for this one. Oh, so the expert, according to the expert, he will tell. And we say the expert is in two categories, the expert and non-expert. So the expert is that person is the professional, who is professional in the way of doing things, and non-expert is that person who is not professional, but somehow, somewhere can be guided over some aspects. So we'll go ahead and read the exemptions to the rule. Exemption to the rule, which rule? Exemption to the rule of where, when secondary evidence can be used. Secondary documents can be used in court. Basically, if primary documents were destroyed, or if primary document is in its original form but cannot be moved, or the nature that it is not movable, so the secondary evidence can now be allowed to be used. Read section 64G shows that, and section 64C shows where the original has been destroyed. And many more. So basically read section 64, you'll get to understand all those. And read the case of Lakman Raji versus Sheji and Son, where the appellant says that he received the check but never showed the letter. The respondent produced a carbon copy of letters as evidence. So these are some of the instances where secondary evidence secondary documents can be used or be relied on. Now you will go through and read what we call the presumptions, retained documents, but again you will go and read the parole rule, the parole evidence review.